Hello everybody, welcome to this next plenary session on early constitutional steps and choices. My name is Bevan Martin from the Vic Law Faculty, and it's my pleasure to introduce first for you today Ben Gussen. Ben is a barrister and solicitor of the High Court of New Zealand, and he is currently teaching law and economics at the Auckland University of Technology and the University of Auckland. He also holds graduate degrees in engineering, business administration and law and economics, and at the moment he is studying for his PhD at the University of Auckland.
Hello everyone, thanks Bevan. So first of all, I just want to thank you for giving me this opportunity to share with you some of my thoughts on the New Zealand Constitution, early steps, but also sort of current trends that might also give us some direction as far as constitutional change is concerned. As Bevan said, I'm currently working on a PhD in law and economics. So my sort of main area of interest is constitutional political economy, which is basically James Buchanan and ideas that emanated from his work on the what's known as constitutional economics. This paper touches on that point, but before I go there, I will just go through the content. So I'm going to limit, of course, my presentation to 20 minutes, but I'm going to hopefully cover the introduction, and then we're going to go through parts 2, 3, and 4, and finally I will conclude. But my conclusion really is in this slide over here. I like sometimes actually to move around, and I hope that's all right with the cameraman. If you don't, they can't hear the So basically what I'm saying on that slide is that my sort of argument, my main argument, is that subsidiarity, and I will explain what I mean by subsidiarity, is an implicit constitutional principle in New Zealand. How would you get to that point? How could you actually make such a claim? We're going to go through what subsidiarity really means, especially its three core principles or sub-principles. And we will look at, in particular, the constitutions of 1852 and 1846, including also the Treaty of Waitangi, and make the links between subsidiarity or the core of subsidiarity and these instruments. So the introduction basically follows what I have in the paper. It's the same structure that you have there. I start by talking about the idea of quasi-federalism. The Constitution of 1852 was described as a quasi-constitutional, quasi-federal constitution. In that constitution, Section 2 established 6 different provinces, which were really the early colonies in this country, a development that you will find in other jurisdictions, in particular in New England, which I make an analogy between New England and New Zealand, and I find that at least others describe this constitution as quasi-federal. But I move away from that notion because I find that quasi-federalism is a little bit vague. You have to really define what you mean by quasi-federal and why it's quasi-federal. And I find the idea of subsidiarity as a better way of looking at this constitution, the Constitution of 1846, and the Treaty of Waitangi. So in the second part of the paper, we talk about a constitutional experiment. This is the 1852 provincial system. So of course there were attempts to decentralize since the Treaty of Waitangi. The first attempt was in the 1846 Constitution, when we introduced 2 provinces, New Ulster and New Munster. Of course, that 1846 Constitution did not become really operational, and it had to wait until we came up with the 1852 Constitution, when we introduced our 6 provinces, and basically under that Constitution, under Section 2, the country was divided into the 6 provinces: Auckland, New Plymouth, Wellington, Nelson, Canterbury, and Otago. Section 3 of that Act made sure that this is the structure of the legislative councils for these provinces was entrenched, but of course there were restrictions on their legislative powers. That's where the quasi-federal comes from. So they were always under the control of a central government, which was basically under Section 19 of the Act. I talk about the nexus between this Act and the Treaty of Waitangi. In particular, there was a Section 71, which basically related the aspirations of the Maori in that constitution. It never, of course, became operational as well. But it gives you sort of a line of arguments where you could say that there was this flow from the Treaty of Waitangi to the 1846 and to the 1852 constitutions. And that line of argument I will sort of marry, if you like, with my analysis of subsidiarity and its core principles. In the paper in section B, I talk about 2B, I talk about the internal reasons for this provincial experiment. So I sort of divide them into internal and external reasons. And I talk, for example, on the internal reasons about, first of all, the governance problem. I explained there that at a very early stage of New Zealand's constitutional, this constitutional experiment, New Zealand was sparsely populated. We lacked really the political sort of depth where we could have politicians to represent the central government, plus other issues that sort of gave us this idea of having provinces first, from where we can move into a stronger sort of central government. So I also expand on things like the demographic changes that were happening, the number of settlers at the time, all of which I interpret as a governance problem. The second part I talk about there is the financial collapse. At least if you read commentators on the provincial system of that period from 52 to 76, they tell you that the main reason for the collapse of the provincial system was really financial. The idea that these provinces were borrowing too much, and which this, ended up basically calling for the intervention of the central government, and the central government putting a hold on their ability to borrow any further. So basically the financial controls, the reins were now transferred to the central government, and that was sort of the first step towards the abolition. So in the third part of these internal reasons, what I interpret as internal reasons, we talk about the asymmetry of provincial legislation. This was in particular something that Julius Vogel looked at and found quite difficult to sort of work with. Of course, he was pushing for a public works policy that wanted sort of to advance colonization in New Zealand. And it was important that you would have sort of a harmonization of policies, for example, in relation to railways at the time. Then I move on to external reasons. And external reasons, again, I divided into three reasons. So the first one I talked about was technological limitations and technological progress. At the time they were established, the provincial system was established, there was actually difficulty in transport, difficulty in communication. By the 20 years between its establishment and abolition, huge steps were made into actually reducing that gap. So you'd find that communication and transportation became much more easier, which meant, of course, that you could have a strong central government that could be, responsible or in control over the whole of New Zealand. Then I talk about the commercial interests of Great Britain, which some of you might find a bit far-fetched when I talk about the analogy between New Zealand and New England. Back in the day, of course, there was a Dominion of New England that was established after there were 6 different colonies in New England. And some commentators would tell you that the establishment of the Dominion was mostly because of economic reasons, which recalls to my mind Charles Beard, for example, and his economic analysis of the American Constitution, that there's always a subcurrent, an economic subcurrent behind any constitutional change or constitutional setup. In New England, of course, the Dominion collapsed, the settlers there basically revolted against the idea of the dominion. And I describe in the paper on page 9 the reasons for its creation and then what precipitated its collapse. You might even find analogies or draw some similarities between what is happening now with the New Zealand economy, the setup of our New Zealand economy, and what was happening in New England at the time. The idea that we still can probably have much more we could do on areas like technological advancement and innovation. The economy at the moment really is mostly about staples. Of course, there's technological, of course, we have technology sort of involved in things like the dairy industry, meat processing industry, but there's much more that we could do rather than stay in that area of actually providing mostly, if you like, raw materials or just lightly processed raw materials, rather than focus on innovation like they would do, for example, in Europe or in North America, in the United States in particular. Then I move to a third, what I call external reason, the 18th century political fusion in Europe and the US, where I talk also about changes, constitutional changes that were happening in North America, especially the Canadian, what they call the British North America Act of 1867, and the sort of consolidation movements that we saw in Europe, the unification of Italy, the unification of Germany, and generally sort of a tendency towards moving away from decentralization, if you like. The third section of this paper talks about subsidiarity within the New Zealand context, New Zealand provincialism. The first part provides a brief introduction of the principle of subsidiarity. Maybe suffice it to say here that it has an economic as well as an ethical reason or background. And this goes back really to the Catholic Church that introduced both, almost both, the economic and the ethical reasoning. The economic one takes you to the genesis of the welfare state. So I have it there, but unfortunately I think that's not legible at all. So it basically talks about how the welfare function developed from the subsidiarity principle. It says basically that the central government shouldn't intervene as long as there are social organizations below the national level that could take care of the welfare function, all the way down to the family. Once you don't actually have any of these levels available to the individual who is in need of welfare, then the central government intervenes, not the other way around. So this is one sort of ramification of the origins of subsidiarity. It says basically that the larger organization structures should leave to smaller organization structures whatever they can achieve on their own, plus help them to do so, rather than take over the function itself, like the welfare, for example, function we see today in almost all Western governments. The other, of course, part is ethical, which pretty much talks about the same requirement, but from a sort of liberty, ethical perspective, where you allow people to be in control of their own sort of destiny. Of course, subsidiarity today is a big area of jurisprudence, especially in the European Union. It was part of the Maastricht Treaty, and now it's, of course, part of the Lisbon Treaty, and you find that it's gaining momentum also in Northern America. So that much more interest in how subsidiarity works relative, for example, to things like federalism. The most important point probably I need to emphasize is that subsidiarity straddles both unitary and federal states. So we looked at two constitutions. One of them is the Polish Constitution. So this takes us to the provincial system as an application of subsidiarity. And I think, starting from page 14, we talk about similarities between our instruments like the 1852 Act and other acts from Canada, from South Africa, and from Australia. I look at their structures, and I argue that there are similarities in the intent. Morrell, for example, one of the early commentators on our Constitution, said that if this quasi-federal experiment continued, we would have probably been going through down the path of federalism similar to, for example, the federalism that we see now in Canada. But the point I want to go back and emphasize is that subsidiarity is relevant to both unitary states and federal states. So I looked at the Polish Constitution. In the preamble of the Polish Constitution of 1997, you'll find that there's an explicit reference to the principle of subsidiarity, while I think it was Article 1, the first article talks about Polish as a unitary state. You also find in the Swiss Constitution, the Federal Constitution, 1999, you find similarities. They talk about in the preamble, and then they emphasize that this is a federal state. So you could apply subsidiarity basically regardless of whether you choose a unitary or a federal setup. Given the time constraints, it's best for me to continue and talk about the Treaty of Waitangi and subsidiarity. We say that subsidiarity has three different sub-principles, and I talk about how these sub-principles can be interpreted in relation to what we see in articles in the Treaty of Waitangi. And I see that there is a strong correspondence between such principles coming from subsidiarity and, if you like, the principles that we also see in the Treaty of Waitangi. In constitutional design, I want to emphasize the point about economics, which is the point I make on page 18 of the paper itself, where I talk about the work by Charles Beard and also by James Buchanan. The idea there is that you have two different types, in a nutshell, two different types of costs. And when you compare these costs, some of them are going, you would be able to find an optimal scale for the political unit. And they find that the optimal scale for the political unit is actually smaller or lower than a national scale, which is basically the idea of subsidiarity, where you would be able to have a political organization at sort of the scale of the city or the scale maybe even of the province. And if I just could end on that note, so this could have, for example, implications, for example, in Auckland, the Auckland supercity. Auckland supercity currently is looking at possibilities of, for example, finding different venues for different possibilities for revenue. And this idea of subsidiarity could be looked at where you would find a different relationship between the central government and a supercity like Auckland, and how we can use something like subsidiarity to improve their well-being, to improve their innovation, etc. I will leave it at that point because if I try to sort of flesh it further, there might be much more difficulty really coming to a consensus on what we would agree on as far as subsidiarity in that context would mean. And I'll leave it there. Thank you.
Thank you, Ben. I'd now like to invite Peter Mckenzie QC to address the floor. We have in Peter a lawyer from both the academy, the government side and the practice side. He was a former member of the faculty at Victoria. He's worked for the Securities Commission and other government roles, and also practiced at the bar and in a firm. So, welcome, Peter.
Well, thank you for those words of introduction, and I'm grateful too for the opportunity to bring to you this afternoon a figure that I find of real interest in our early constitutional pilgrimage, if you can call it that, and that is the first Chief Justice Martin. I think he's a very interesting figure because he exemplifies really what Jeff McClay was telling us this morning, in that his contribution to the significance of our constitutional arrangements doesn't derive in any great degree from the judgments that he gave. His court decisions, to some extent, he was overshadowed by Chapman, particularly in the leading case of Simons, who was a much more dominant personality and liked to have the limelight. Martin was the opposite. But his contribution came from really the integrity and simple authority that he embodied. He was, of course, New Zealand's first Chief Justice, and as such an authority figure in the new country. But more than that, his integrity and his knowledge of Māori language and the respect that he had for the Māori people and they for him meant that when he later, as an ex-Chief Justice in retirement, spoke out vigorously and wrote even more vigorously in challenge of decisions that were being made then by the government, both first in UK and then later in New Zealand. He was listened to with, albeit grudging, respect even by those who opposed him, because his knowledge of New Zealand and particularly of the Māori people made him a very difficult individual to personally challenge. And I think one of the interesting things about Martin is that both sides of the debate really didn't rise up to denigrate Martin, and even though he spoke out in a way that was improper for him as a holder of judicial office in his first publication, which we'll see, really his critics did not denounce him. He got his pension, and albeit grudgingly perhaps, he got his knighthood. Fortunately in 1860, because after that he published perhaps the most vigorous of his works on the Taranaki question. Maybe the knighthood would have been withheld if he hadn't got it. But looking at Martin, perhaps if we could just move it on. Yes, thank you. I'll leave you with him there. In somewhat clerical garb, and he perhaps was a clerical figure in some ways. He was a very close confidant of Bishop Selwyn, New Zealand's first bishop, and they travelled out to New Zealand together and of course were both staunch members of the Anglican Church, and Martin made a significant contribution there, which I haven't got time to develop. Well, there are 5 areas of his contribution that I want to speak briefly to. I may have to omit the last of them in the interests of time, but they are that he sought to establish a unitary system of justice. He modelled the rule of law in the new courts. He made a significant contribution to the wastelands debate and the place that that gave to Article 2 of the treaty. His understanding of the Maori version of the treaty, being one who was in command of and fluent in the Maori language, is, I think, worthy of greater respect than perhaps many historians have given to him, because the 2 key phrases that so divide us today, or have been so contentious, I won't say divide, contentious today, were pronounced on by Martin, and I think his comment deserves very serious consideration. And then finally, the land confiscations and the law. Establishing a unitary system of justice. Martin came to New Zealand at a time that he called a transitional period, immediately after the treaty. And I think we have to sort of step out of our time to really appreciate the challenge that he and others who were establishing institutions in New Zealand faced then. About 80% of the population of the country was Māori. Settlers were a very vociferous lobby, and the early colonial press, and perhaps as Sir Geoffrey indicated to us, pays tribute to that. And so he faced the task during this transitional period of introducing a court system, particularly the superior court system, into New Zealand, gaining respect for that court system from both sections of the population, and in doing so to commend to Māori that this way of doing things would benefit them. And his writings have got many statements which I refer to in the paper, in which Martin indicates really the earnestness with which he pursued that particular cause. And I think what we need to realise here is the two sort of areas of potential conflict that he faced. One was that British settlers regarded it as their birthright to take with them the English jury system, the general framework of the common law, the Magna Carta, and the rights and freedoms of Englishmen, hammered out in the time of the Stuarts. And of course we see that in what Sir Geoffrey told us about this very vocal meeting of settlers in Nelson in 1850, and that was characteristic. People knew their rights in a way that, sadly, as Sir Geoffrey pointed out, they're unaware of them to a significant extent today. These were people who were vociferous about their rights, and as Englishmen, and they had a judgment of Lord Mansfield to support them, they took that inheritance with them when they established a new settlement. So they must be governed by English laws and English liberties. But at the same time, Martin was very aware that the Maori population had their own customs. He called them laws and customary usages. And you'll see the citation in the paper. So he was very conscious of that. And yet at the same time, he sought to establish a unitary system of justice, a common system of courts, and to do so, therefore, he felt that he must commend to Maori that what he offered had benefits for them. And so that peacefully, in this transition period that he referred to, they would move over and accept a common system of justice in New Zealand. And in doing so, it's interesting because it comes out in other papers that we've had in this conference, and I found it fascinating actually to see the number of themes that are picked up as I've read about Martin and his particular period. And this was that Martin wrote that Maori were particularly receptive, he felt, to English legal institutions and the jury system. And one of the factors that he refers to is the fact that Maori reached decision following discussion and debate, and that there was open decision-making amongst Maori. And of course that's a feature of Maoridom still today. And so the trial system of presenting the case for the prosecution, and then getting up, presenting the case for the debate, the argument that took place through cross-examination, and then the addresses to the jury, and then the jury itself, a group of course, men in those days coming to the decision, fitted in with a Maori understanding of justice. And so Martin felt that if he worked hard enough and used his court as a model, that he could persuade Maori that this was a better way. And supported, as I've said, by the strong desire on the part of Maori for a settled legal order, and that's come out in a number of our papers today, this week. Martin was very critical of government's failure to really support him in that exercise, and that outside the areas of settlement, little was being done to develop, he said, the resident magistrates' courts and what he called native circuit courts, which Governor Grey had instituted, but which were not really developed very adequately within those areas of Maori occupation. And I found it fascinating to hear the paper from Professor Dorset yesterday about the way that the resident magistrates' courts within the areas of settlement, Wanganui and in Auckland, apparently much less so in Nelson, were significantly used by Maori. They readily adopted and could see the benefits of this way of resolving disputes and made use of those courts. But Martin was critical that government hadn't extended that system of courts further. In modelling, coming to the modelling of the rule of law in the new courts, Martin, in his very first murder case, which is about the second case he took in Auckland, was a trial that engendered a great deal of publicity. The court was crowded with Maori. It was a case where Maori had, up north, had murdered not only Europeans but also Maori, and it was watched with anticipation. Martin made sure that the proceedings were translated throughout, of course, into Maori. He arranged for counsel, and the very first point that was taken was probably one that Martin himself made sure was taken. That was counsel for the accused argued, well, this court should not try the accused. According to English law, Makatu has no knowledge of English law. It is unjust and unfair to put him on trial here. And Martin's first ruling there was no. The third article of the treaty provides that both settlers and Maori are British subjects, and Maori are to come before the Queen's courts and be dealt with in accordance with the Queen's law. I'll come later to the fact that Martin certainly allowed for a diversity of customary and local practice. But so far as the maintenance of law and order and the criminal law was concerned, for him there was one law and one court. And of course that's a practice that has continued ever since, and I could in paper mention perhaps the latest case in the long sequence, the Queen and Mason, Justice Heath, a very interesting case incidentally, where he goes into some detail on the questions of customary usage and the extent to which that can still be resorted to today. Then just briefly, because I think it's an interesting example of a case that went seriously wrong for Martin. At this stage he didn't have Justice Chapman. It was the early period before Chapman arrived, so Martin sat in Wellington. And in Wellington they dealt with cases from Marlborough and Nelson. And it was a case in the Marlborough Sounds where a settler had murdered the daughter of a high-ranking local chief and her child. So Māori were watching very closely what was going to happen. Would this system of justice work for them? Unfortunately, it was bungled by the prosecutor. Witnesses who were meant to go over to Wellington weren't sent the expenses for the fare, and there were all sorts of problems there. And it ended up, therefore, with the wife of the accused really as the sole witness. The prosecutor was taken by surprise when counsel for the accused raised spousal privilege. She can't give evidence against her husband. The case collapsed. Martin had no option, but the settler was there, English law had to apply, and the English privileges had to apply. The settler walked free. Maori naturally were outraged. Shortly afterwards, 4 settlers were killed in the Sounds. No one knew why, but I'm sure Martin had very serious misgivings as to what had occurred. And when the Waro incident took place, one of the issues that was brought up and thrown back at the governor at that time was, well, justice was not done in Qc's case. So there were serious consequences if miscarriages of justice took place. Māori watched closely to see that this system delivered. Martin went further and he endeavoured to provide in Māori a handbook, Ko Ngā Tikanga a Te Pākehā, in which he wrote about the law and customs of the Pākehā to seek to explain to Māori, going through the processes of an ordinary criminal trial, what was involved in the court process. That commended itself to Māori and in fact was republished in the Māori Messenger, where it can be accessed. So Martin did his part, but unfortunately, as we shall see, of course, his efforts were to a significant extent frustrated, particularly in areas such as Taranaki and Waikato, and Martin's good work, if we can call it that, really did not produce the fruit that he had hoped. We come to the wastelands debate and the treaty. was asked yesterday why it is that New Zealand, settlement in New Zealand proceeded so differently from that in England. And I think the answer was partly given to us by Professor Fisher this morning. I think what's very interesting is that New Zealand was settled in the late 1830s and 1840s at a time when the missionary movement and the evangelical movement in England, if you like, had captured the colonial office. And why had that happened? A very significant House of Commons report was given in 1836 on the protection of Aboriginal peoples. And that report, which was deeply influenced by the evangelical movement, because they had taken over the banner of the anti-slavery movement, and the successor to that movement was now in the House of Commons and promoted this particular report in words that we would find today extremely strong. British colonial practice was utterly condemned, was described as being appalling. What had happened in North America, what had happened in Australia was mentioned too, the Aboriginal people there, and South Africa. New Zealand was going to be different. That society at first opposed any settlement in New Zealand, as did the CMS, the missionary organisation, but later came to agree with Stephen, an interesting quote in Professor Fisher's paper, that New Zealand was so full of lawless people coming from England and Australia that it would be better to bring settled government into that country. So the Aboriginal Protection Society changed its tune and said grudgingly, well, we'll accept settlement, but with safeguards. The safeguard was the treaty. And so the treaty was entered into in New Zealand as really part of the price that the New Zealand company had to pay if it was going to get the Colonial Office to agree to settlement here under a British governor and administration. The problem that arose 3 years later, in 1844, 4 years later, and we haven't time to go into it here, I have to leave you to read the paper, but a very significant debate took place then in the House of Commons, engineered by the New Zealand Company, and they brought in aid the writings of Vattel, a constitutional writer of an earlier period, but whose writings had recently become, or more recently become available in England, armed also with their being adopted by Dr. Arnold of rugby school fame. The debate really ended, although in favour of the New Zealand Company. In fact, the war was lost at that time because the Colonial Secretary was talked over by the Aborigines Protection Society and the CMS into delivering a very strong statement in support of the treaty. But the administration changed. Those who had supported, in the Colonial Office, who had supported the treaty, were now out of office. Earl Grey became Colonial Secretary within 6 months, and he was a strong supporter of the New Zealand Company position. Introduced a new constitution for New Zealand, the first constitution for New Zealand in 1846, so very soon after settlement, and adopted the view that the wastelands, this was the view New Zealand Company was espousing, the wastelands did not belong to the indigenous people. They, by virtue of the Crown's sovereignty, were vested in the Crown, who could allocate them to whom it would. This was, in Martin and Selwyn's view, strongly opposed by Article 2 of the treaty. They read that article in a very different way. I haven't time to go into the debate here, but Martin took a prominent role in that debate through a publication that was issued in England and to a few friends in New Zealand, supposedly without his being party to it being revealed, but of course that came out. And that was an embarrassment for Martin, but as I've said, because of his position and the integrity with which he, and respect with which he was held, no action was taken. The outcome, and I'll just mention this before we close, the outcome was many years later. Well, there were two outcomes. One, in 1852, that statute was reversed, repealed, the 1846 Constitution replaced by the 1852 Constitution. In the meantime, the 1846 provisions were suspended because of the outcry in New Zealand. Astonishingly, the 1852 Constitution still made provision in a more guarded way for wastelands to be allocated by the governor under that act. But the provision was not implemented, and the last word was given by Martin in a Court of Appeal decision, believe it or not, a judgment of Chief Justice Stout, who one would not have expected to be supportive, in 1912. In Tamihana, Korokai, and the Solicitor General, the Court of Appeal, led by Chief Justice Stout, citing Martin and Selwyn and the debate that had taken place, an extrajudicial pronouncement, took it as unquestioned that all of New Zealand initially was vested in Māori. And that's never been questioned really by our courts since. So in that sense, I think that very significant aspect of our constitutional arrangements, and which of course has been important more recently, Martin on that had the last word. Well, we'll have to leave things there. I think I've run out of time, but I'll leave you to read the paper on the interesting commentary that Martin makes on the Māori version of the treaty and the words kawanatanga and tino rangatiratanga, which of course have engendered a good deal of controversy today. The point that I make there is that if one understands the change that took place in 1844 in terms of the debate that took place over the meaning of the treaty and the meaning of sovereignty under the treaty, one can understand that the ground had shifted from 1840. Martin espoused the position that was initially held by the Colonial Office, Hobson, Henry Williams, and those that framed the treaty. But the ground had shifted later, and the paper argues that it would be a mistake to accuse Williams of deception for translating the treaty in a way that would have been understood, as Martin understood it, and preserved Article 2 in a form that's consistent with tino rangatiratanga.
Thank you very much to Ben and Peter. We now have some time for some questions, and Claudia will have the roving microphone. So if people just indicate there. I have two questions, one for each presenter. And
am I audible now? Yes. Ben, on your paper, I would, without arguing or attempting to challenge anything that you were saying there, I wonder if you could add another element to the Dominion for New England that you were talking about, in terms of the politics of all of that and the challenge that it posed to self-government, to the town meetings, to the land titles, and to a good many of the rights and liberties, and also the role of Andros in that. And then for Peter, I think that's an excellent paper, very instructive to me. I learned much more about this fascinating story of Judge Martin from you than I have anywhere else. And I'm wondering how far he went in the study of Maori law. He appears to have been a deep student of Maori culture, knew the language, learned the language. Did he think of a kind of integrity to Maori ideas of law that could be recognized or incorporated in some ways?
So I'll just put a gloss on what I've just talked about earlier. But if you want to read so if you want to read really more about what happened in New England and the creation of the Dominion of New England, you'll find it on page 10 of the paper. But again, very briefly, we're saying that you could see parallels between our constitutional experiment, the creation of these provinces, and their abolishment, similar to what happened in New England 100 years earlier. And the ideas there are definitely as much political as economic. So we talk really the influence of political economy in the creation of the provinces and then their abolishment, or at least the attempt by England to abolish them through the creation of this dominion. The point was that in New England, the settlers didn't have enough stables to go on, in the sense that their economic activity was centered more around innovation and trade. Some historians, American historians, the references are there in the paper, suggest that this was, let's say, not in the interest of England at the time. So England attempted to first of all reduce the cost of managing New England by eliminating, instead of having 6 governments, to have only one centralized government. But the important thing is that the policy of that government would be to move New England from an economy that competed directly with England to an economy that was based on staples. So the idea was that it would end up, exporting dairy products, meat, timber, that could then be used by England for further processing, manufacturing, and then trade. And my claim, basically, in the paper is that even today you could see that, I thought I referred you to the Atlas of Economic Complexity, which shows you really the structure of the music economy today. And some of you might disagree, but in my eyes, I can see still the same trend. There is no serious move towards innovation or towards trade, even though now we're having more and more free trade agreements with many countries, etc. But what we are trading, all I'm saying is that they could have much more to do in New Zealand if we move away from this idea of stables. And I put it back to this historical context, and I make the analogy with New England. So that's basically the point.
Yes, just dealing with the question about the extent to which Chief Justice Martin might have become involved in developing, or at least articulating, Maori, a system of Maori law and customary usage. It's interesting that in the Taranaki question, which was one of his major works, written in opposition to the conduct by the government of the Taranaki War, he has quite a lengthy section on Maori land tenure and Maori customs in relation to landholding. That was received with varying degrees of support by and opposition by settler groups. But all acknowledged that he certainly had an intimate knowledge of Māori customary practice so far as land was concerned. Outside of the area of land holding, yes, I think there would need to be more work done to know to what extent Martin developed or articulated Māori customary practice in those areas. Certainly he supported moves on the part of government, or thought that government ought to make moves to develop within areas of Māori occupation a system of justice that would reflect and adapt to Māori customary usage. But I'm not aware of the extent to which he himself developed a jurisprudence there.
Yes, Peter, I'm Barry Rigby. I work for the Waitangi Tribunal, and I'll be offering evidence on this question on Tuesday in Kerikeri. So I'm pleased to see that there's no Crown Counsel available, but Damon will probably inform Andrew Irwin about what I'm about to say, which is that I don't think that evangelical capture of the Colonial Office stands up to the treatment, for example, that Mark Hickford gives it in his book, Lords of the Land. I think it's a much more complex situation than James Stephen drafting Norman B's instructions and opposing the wasteland instructions in 1846, when you rightly point out the New Zealand Company captures policy. But I was very surprised to see in Mark Hickford's book, which was published just a couple of years ago, Lords of the Land, that he believes the people who drafted the wasteland instructions December 1846 were Charles Buller, major New Zealand propagandist in the House of Commons, of course Earl Grey, who had been, as Lord Howick, same person, but chairman of the pro-New Zealand Company House of Commons Committee on New Zealand in 1844, that you rightly pointed out, turned the tables on the humanitarian policy. But he also says that Benjamin Hawes, who was the parliamentary undersecretary under the Whigs, and James Stephen Jr. were drafters of the wasteland instructions of December 1846. I take it that you're not aware of that book?
I'm aware of it, but I haven't studied it for the purposes of the exercise today. But certainly what you say is interesting. If James Stevens Jr. had a hand in the wastelands, the 1846 Constitution, certainly that was towards the end of his period in the Colonial Office, and it may well be that he saw the tide running in different directions at that point of time. It would certainly seem to me to have been inconsistent with the position that he adopted 4 or 5 years earlier in the debates that led up to the treaty.
Thank you very much to our two panellists. We have to change, the others will invade the room now, so we'll wrap up there, but thank you very much to Ben and Peter for their presentations.